So here's an estate planning tip that most lawyers don't explain and most clients never hear often enough. Most estate plans don't fail because the documents are bad. They fail because the plan isn't funded and the authority doesn't match the assets. Now before I explain that, hi, I'm Jason Wagner, the farm lawyer. I work with family farmers every single day to help them pass the farm on to the next generation. At my firm, Wagner Ayler, we've been doing it for over 50 years. Watch this video to learn more. So when I say this is where plans break, it's because we see it happen in the real world. Here's what people miss. People sign the will or the trust, they sign the power of attorney, then they assume everything is handled. But documents alone don't control assets. Ownership does. And that is something we emphasize over and over and over again and help our clients along the way. How do we get these assets actually into the trust so that the trust can control the assets? We went through all of this work to say, here's how we want things to happen when we die. But if that trust doesn't actually control the asset, as in own it when you die, your trustee doesn't have the ability to direct it or to distribute it the way you want it. So title matters. Beneficiary designations matter. If those don't line up, the plan can break. Now, at our firm, it's our practice that if we know about your real estate, and we do ask you several times throughout the process to make sure we've got it all, we will make sure that that real estate, one way or another, gets tied to the trust. It will either be owned by the trust directly, or it will have a transfer on death deed to the trust. But where it often fails is either you didn't tell us about a piece of real estate, you forgot a piece of real estate, especially you say you sold it on a contract for deed. Well, you know what you forgot is that a contract for deed means you still have the deed. It's in the name. It's a contract to give a deed in the future. So if you still own that piece of property, we need that in your trust. Or what I often see is clients are buying property and then don't tell us about it. So that's a good reason we like to have a review appointment every 3 to 5 years. It's an easy way for us to catch that. Have you purchased any other real estate? So that way we can make sure it gets into the trust then if we didn't know about it at the time of purchase. Now at my firm, we do real estate transactions. So if you're closing with us and we did your estate plan, we can line those up at the front end. We don't have to have another appointment or another deed later on to get it into the trust. We can do it at the front end at the time of purchase. But even if we're not the ones closing on it, it's simple enough to just check in with us and say, hey, I'm buying this new piece of property, or I'm buying a townhouse. How should I have it titled? That 5 minutes of effort can save us hundreds of dollars later on because I can connect with whoever is actually closing for you and let them know this is how we want it titled to align with the rest of the real estate. Business interests, we have to make sure those are properly assigned. What about bank accounts if they're not retitled? Now, thinking about checking your savings accounts, I often like to use pay on death designations. The reason being is that then we don't have to get new checks and you don't have to get a new account number. Some banks vary on this, but all banks allow you to put a pay on death designation. So we can put that POD to your trust. So that way, if something happens to you, that bank account falls into the trust upon your death. Now think about it. If you're a farmer, sometimes that bank account is holding, hundreds of thousands of dollars. That is not an insignificant asset. You're thinking about it as not a big piece of property, but at certain times of the year, it is a big piece of property. I know things are moving in and out of it, but they're moving in and out of it because you're alive. At the time of your death, things are going to stop moving in and out quite as drastically. And we don't want to be stuck with $500,000 in the farm checking account and no beneficiary designation, and even worse if it doesn't follow the plan. So when something happens to you, we need to make sure the trust can do its job. Another example, power of attorney exists. But if it doesn't authorize real estate transactions or gifting or business decisions, we can be stuck. We can get into a dead end. So even though the document exists, if you haven't worked with an estate planning attorney who understands the ins and outs of farm and business and gifting and estate taxes, they may not know that this power of attorney needs to cover more than just writing checks and paying bills. It needs to cover much more comprehensive situations so we can make sure that your farm survives your incapacity and that we're being tax efficient and can continue any gifting that you've been doing during life. So good estate planning is about matching the authority with the assets and real world decisions. Your farm and your business make this so important, and these decisions can't wait. And it's all the more important that you work with a farm lawyer when you're doing this. You don't want to work with somebody who dabbles in wills and trusts or advertises cheap wills, because that's exactly what you're going to get. A cheap, dabbled up will that doesn't actually do what you think it's supposed to do, and more importantly, doesn't do anything to protect the farm. Same thing with a trust. If you don't have a trust that's properly funded and doesn't have assets match the trust, you can end up in probate, which may be one of the reasons you went with a trust in the first place. Courts move slow. Your non-farming heirs or other people can have an opportunity to contest at that point. So we don't want to focus on documents. We want to focus on that knowledge and advice you get by working with a experienced farm lawyer who knows exactly how to approach a situation because they've done it every single day with other clients. These aren't just simple decisions that we want to just write off. These are operational, dynamic, and generational. This is something that we need to make sure your plan has a sanity check and that the values you want to move forward are reflected in that plan. So you've got to ask yourself 3 questions. Number 1, what are my assets that I actually own? And don't think that there's anything that you shouldn't include. Dig deep. Have I sold anything on a contract for deed? Have I bought anything on a contract for deed? Did I inherit something with my siblings where I maybe own a 1/5 interest? Do I have mineral rights? What about my condo? These are all things that people often forget about. Second, does my power of attorney clearly authorize real estate transactions, business transactions, trust transactions? Does it allow gifting? If you don't know the answer to that question, you probably didn't work with the right lawyer. Third, could my family actually act tomorrow without court involvement? Now that, of course, is one of the biggest questions, isn't it? Because we're talking about your dignity, your privacy, ease of administration, and keeping costs low in the event of your death or incapacity. If you can't answer that question, that's a warning sign. So if this kind of practical, under-the-hood guidance is helpful, subscribe to the channel. And if you want help reviewing your will or your trust and your farm estate plan, check out farmlawyer.com. Any one of the attorneys at Wagner Ayler or me would be happy to work with you to make sure that the plan that you have accomplishes what you need in order to protect your farm and move it to the next generation. Thanks for watching.